first of all, I really want to thank y'all I think we've got a pretty good crowd here. We were joking earlier because unless y'all, I hesitate to even mention this, but George Foreman is in the house next door at the same time as this schedule. So I didn't set that up. I apologize for that. But if you get a chance to meet him afterwards, feel free. I do think this is an exciting and timely topic. We're going to talk about regulatory reform and ways in which we can maybe limit the growth and number and severity of regulations here in the state of Texas. And we've got a terrific panel that I'm going to introduce here in a second. But I also want to start off with some timely news. Just this morning, I saw the Bureau of Labor Statistics report that came through the Workforce Commission. And this is getting to be a broken record, but once again, Texas leads the nation in job growth and economic expansion. Yeah, absolutely. Cheer it. Cheer everybody that's working in the economy too. Cheer yourselves. In fact, according to those statistics, Texas has now 115 months of consecutive job growth, well above the national average. We have set a record in 2019 for the lowest unemployment rate since the Bureau began collecting that series of data in 1976. So it's fantastic news across the board. If you were here this morning and you heard some of the discussion about the great economy here in the country, Brooke Rollins, who of course is from Texas and had some great expansion role here with the foundation, is now in the White House and is very proud of the work that this administration has done on a national level. And she mentioned a couple of things that we talk about here in Texas a lot, and that's taxes and regulations. And I remember years back when I was working in the Perry administration here in Texas that we used to refer to it as the Texas miracle. And the thing that Governor Perry always stressed was low taxes and reasonable regulations. Now, I have to remind everybody what that means is low taxes, not no taxes, and it also means reasonable regulations, not no regulations. We do have quite a few regulations, as many of you know. In fact, we probably we'll have an expert here in a little while talk about where Texas ranks in that statistic, but we have a lot of regulations in Texas. Back in the days when I was a regulator, I'm partly responsible for some of that, so I apologize. But a lot of the regulations, of course, come from statutory and legislative directive. At its core, a regulation has the force of law. So it is a law. People forget about that a lot of times, and a lot of times we kind of ignore what state agencies are doing. But it's very important to focus on that because the legislature obviously adopts the laws, and then it's up to the executive branch to implement those. But the legislature, in the enacting legislation, directs and authorizes all these different state agencies scattered across the state, most of here in Austin, but scattered across the state, with the power and the direction to implement by adopting new rules and regulations that further the detail, that add detail. And if you know the old adage about where the devil lies, then you'll know why you have to pay attention to what the state agencies are doing. So with that, I'm going to talk about the panel we have here because they're going to help us in guiding and looking at ways in which we can take a look at the number of regulations, both in the sense of keeping an eye on the numbers and the severity of those, as well as challenging the regulations and what we do about furthering our reform efforts at a regulatory level. First of all, we have Jeff Mateer. He's First Assistant Attorney General. With the state of Texas. He was appointed by Attorney General Ken Paxton in March of 2016. He previously served as general counsel for First Liberty Institute, a national religious liberty law firm, after 19 years in private litigation practice. In addition to having received an AV rating by Martindale-Hubbell, he's been honored as a Texas Rising Star and a Texas Super Lawyer. And if you've ever crossed them, then you'll know why. He received his undergraduate education at Dickinson College, where he graduated with honors in 1987, and his legal education at SMU, where he graduated with honors in 1990. We also have Brian Francis at the end. He was appointed Executive Director of the Texas Department of Licensing and Regulation in 2016. He oversees more than 840,000 licensees. Yes, 840,000 licensees in 39 diverse occupations and industries, including air conditioning, refrigerating contractors, barbering, behavior analysts, and the list goes on and on and on. He previously served as Assistant Administrator of the Texas Real Estate Commission and as Senior Securities Analyst at the State Securities Board. He earned his Bachelor of Business Administration from Texas State University with a major in finance, and his Master of Business Administration from St. Edward's University with a concentration in finance management. He's also a graduate of the Governor's Executive Development Program and an alumni of the Transformative Leadership Program at the University of Texas School of Public Affairs and the University of Adelaide in South Australia. Finally, closest to me, we have James Brule, and I'm probably still mispronouncing that. I'll have James correct me later. He is a senior research fellow at the Mercatus Center at George Mason University and an adjunct professor of law at the Antonin Scalia Law School. He authored numerous policy briefs and reports on regulatory issues. His writing has appeared in outlets such as the Wall Street Journal and the Los Angeles Times. He's published scholarly journals, including in the Harvard Law Journal of Public Policy, the Federalist Edition, and the European Journal of Risk Regulation. He received his PhD in economics from George Mason University in 2017 and a BA and MA in economics from Hunter College of the City University of New York. So if you will, before we get started and I start asking them questions, if you would please, let's give a round of applause to our panel. All right, so I'm going to join them down here, get a little more comfortable like we're in a living room. Can everybody hear us? I think so. I mentioned that Texas has a strong economy, but we also have a number of rules and regulations in Texas. And before we get into the tools that we could maybe use to limit those regulations and the severity of those regulations, I'd like to turn it over to Jeff Mateer. And Jeff, if you would explain to us the role of the Attorney General and your role and maybe some of the success that you've had or the challenges you've had in reviewing regulations both at the federal level and maybe even sometimes at the local level here in Texas when you're identifying some regulations that you think need to be challenged.
And thanks, Rod. I'm a little hesitant because one of my clients is here, and I'm going to talk about litigation as a way to limit unnecessary regulations, but not TDLR.
Thank you very much. Thank you very much.
Not TDLR. But no, I mean, one of the things that General Paxton, when he came in, he followed, obviously, then Attorney General, now Governor Abbott, who had been very active in combating the federal government when the federal government exceeds its authority, and especially when the federal government's agencies exceed its authority. And so during the first 2 years of Paxton, we brought 24 lawsuits against the Obama administration. And a fact that is usually not reported these days, we've so far have brought 12 lawsuits against the Trump administration. Although the Trump administration, as I'm sure Brooke shared this morning, has done a tremendous job in cutting back on the agencies and the regulations. There's still a deep state, and at times, even the Trump administration needs to be brought to bear. And so those 36 lawsuits that we in the Paxton administration have brought against the feds can really, for the large part, be brought into, think about three different groups. One is executive order. When the president issues an executive order that exceeds the scope of his presidential power. Prime example of that would be our battles over immigration. We were successful all the way to the U.S. Supreme Court in challenging his DAPA immigration executive order. We won at the Fifth Circuit, and then the Supreme Court divided 4-4 because of Scalia's passing, not on the court, and therefore that decision of the Fifth Circuit striking down DAPA was upheld. Then we followed that lawsuit challenging Obama's executive order on DACA. And that DACA lawsuit, we were successful And the President Trump, rescinded that executive order, and he was promptly sued by the Democrat AGs, and that case is now at the U.S. Supreme Court. So that's an executive order. So executive order is when the President takes an action that is actually the rule of Congress. So in the case of immigration, it should be legislated. It's a public policy issue that needs to go through both houses, then presented to the President. In the case of both DAPA and DACA, those laws couldn't get through, and so the President on his own said, can't get them through, so I'm just going to issue an executive order. Even though, and even recognized when he did it, that's the reason he was doing is because Congress had failed to act. Well, we all know this. Just because Congress won't pass something doesn't give a president authority. And so executive order, that's one thing. Now, in Texas, we really don't have that same sort of, the governor has some broad powers, but the governor does not legislate. It's when the president tries to legislate through executive order. Another area that we have challenged in Texas has to do with agencies, and when an agency, the Department of Education or Health and Human Services, do something that they're now keen on doing called guidance letters. And certainly this was something that was done under the Obama administration quite frequently. Again, so this is where they don't even go through the rulemaking process, but instead they just say, you know what, we want to redefine or expand definitions under what Congress has said, because again, and the classic example is a redefinition of sex. We've had in Congress, there have been various attempts to redefine the term sex under various federal statutes to expand it to other protected classifications. And that has not been able to get through Congress. But through, in some cases, so-called guidance letters issued by whether it's the Department of Education or DOJ or EEOC, they've written guidance letters saying, you know, going forward, we're going to interpret this law, even though since 1964 sex has meant something, you know, we're going to expand that interpretation. So that's an area in which, under General Paxton, we challenged when those attempts to issue guidance letters, challenged them in the courts, and again, it's another situation that where President Trump, when he became president, he directed his agencies to rescind those guidance letters. The third area, which does kind of then cross into some of our discussion about Texas, is when an agency actually goes through formal rulemaking process. And even then, when it goes through formal rulemaking process, our position has been and we've got, I think, the biggest culprit in this is the EPA. So the EPA does have some authority to issue reasonable regulations, but they have to go through the formal rulemaking process. You have to receive notice, have to have the ability to comment. And even when you do that, they have to do it in an area that they've been given authority. And when they act, that rule cannot be contrary to what Congress has said. And so in 12, whether it's the rules related to stream protection or rules related to overtime laws that the Department of Labor did, or the persuader rule, which had to do with the Department of Labor trying to invade the attorney-client relationship. When they did that, Texas again fought back. But those are the three main areas: executive orders, rules, and guidance letters. And so, and to date, we've been very, very successful. The problem at the federal level is there's something called Chevron deference. Chevron is from a case obviously involving the oil company, and that case, which dates back almost 2 decades now, it says that when a court case is brought and there's a challenge to a regulation by an agency, that an agency has issued, that courts first look at the regulation and they say, they look at and say, is it ambiguous? And if they determine that it is ambiguous and that the agency has authority, then the test is simply, is the regulation reasonable? And reasonable means it just has to be one plausible interpretation. It's a very deferential standard. It's very difficult under Chevron for states or third parties to challenge agency rules. Now, the good news is all these people that Donald Trump is putting onto the district courts and the courts of appeal are very committed to shrinking back the Chevron deference. And so we're starting to see cases where we're not just going to give these federal agencies the benefit of the doubt. When a court determines that the statute has given the authority and is ambiguous, and we're just going to say reasonable, we're going to lose a lot of those cases. So that's why it's important. Now, the good news is, and we can get to it in a little bit, is Texas does not have the same standard. And
Well,
I think
in fact,
that's
I was
really
going to ask you
important.
that. So the other part of the Attorney General's authority, of course, is to defend the state of Texas when certain rules and regulations are being challenged by outsiders. So talk a little bit about that standard as you were hinting at, how that differs in Texas, but also what do you and the Attorney General's office, because obviously you have the authority, correct me if I'm wrong, but to either tell that state agency, hey, you're wrong, you've exceeded your authority, you might want to go back and redo those regulations, or defend them in court. So what do y'all look at, and what makes a good rule and a bad rule from that standpoint?
Yeah, no, that's a very, very good question. And with present company excluded, I've been practicing law. I think I'm in my 30th year of law practice. And remember, as a young associate at a big firm in Dallas, that our managing partner once told me I think I was grumbling about a client. Never TDLR.
Who was the other guy anyway?
Yeah, it was in private, right? And he said, Jeff, we just represent them. We didn't raise them. And so we won't use any examples from TDLR. And I think that's, look, we're not as bad as, well, of course, I think, James, you're going to tell us how bad we are, and I'm scared about that. My experience is we're not as bad as we are at the federal level. However, there is room to improve, and I think part of our analysis at the Attorney General's office, yes, we're charged under the Constitution to represent our state agencies. He is a client, and we do represent them. But a lot of our representation, the good work occurs outside the courtroom. And it's before there's a lawsuit, and it's giving advice and counsel, which our folks were together this week on something. And it's giving that guidance. And sort of, the first thing is, look, is this something that the legislature has given you authority over? And it's sort of zero-based budgeting sort of analysis. What do the statutes actually say you're supposed to do as a state agency?
Interesting concept, right?
I know, it's
Look
crazy.
at the statutory authority.
And even more is, those words that they passed in that pink building down there, they actually mean what they say. And we're gonna look at the actual text. And if it says you have authority and you've been given authority, we've been talking about skimmers. You guys know about skimmers. That's not something on a pond that you do or in your swimming pool. It's what they put on gasoline pumps, steal your information. TDLR's in the process. We're working with them as we define rules going after these bad actors and having reasonable regulations for those who are in that business, right? Because we want to stop the bad guys. We don't want them stealing our credit cards. But we don't want to force convenience stores out of business either by putting so many burdensome regulations. So there's a balance. But part of that work is, okay, who's been given authority to do this? What does the actual text say? Are we doing that? And the good news is that the Texas Supreme Court, unlike the federal courts under Chevron, their view is limited deference. They're going to look at a statute and they're going to say the words mean what they say, and they're going to have a very limited view and very questioning. And they're not going. The Texas Supreme Court says, look, we're not going to defer to an agency to say in Texas that sex means something other than what it actually means. And I think that's the positive thing in Texas is that we do have some great. The Texas Supreme Court has been great on this. And it really causes us, from the Attorney General's office, when we're talking to a client, we're looking at a regulation, we're going to ask them, I mean, did you have authority to do this? Is this what the text says? And quite frankly, if it doesn't, then we're going to have a really hard discussion. And there have been, and I don't think with your agency, but other agencies where we've told them, look, we're not going to represent you. Yeah.
So, simple rule takeaway from that is if you're looking at a regulation and you either like it or you don't like it, look at the underlying statute, and that'll determine whether or not that rule can be upheld. Brian, taking that standard, tell us how you always uphold the statutory directive. And,
Absolutely.
And what you've done to ensure that that you're upholding your duties.
Rod, thanks a lot for inviting us out here, first of all. We're with the government. We're here to help you. So our agency is, and it's
I think
confused.
George is still over there.
Yeah, I know. Our agency gets confused sometimes. Everyone thinks we're this giant regulatory beast out there. I have less than 500 employees, and we have over 823,000 licensees and 39 programs and 220 different license types. It's a lot of responsibility, and the way I describe us, we're like a small business. We are a small state agency with huge responsibilities that we take very seriously. And we do start with the advice of our legal counsel and say, what does the law say? The best example I can give you is that in 2016, the legislature saw fit to transfer the regulation of 13 health programs from the Department of State Health Services to our agency. And then the next year they said, hey, we're also going to send podiatry to you as well. That's a lot of stuff coming to us. Well, that inheritance came with over 280,441 words of rules. That's a lot of stuff. We went through every rule they had, and the first question we asked, Jeff, was, is there a statutory basis for this? We discovered that they had a number of rules that were not. Is this something that provides an impediment or a burden on consumers and the licensee population? We discovered that there were a lot of rules that did do that. We eliminated 134,221 words from that list, so 47% reduction. And I appreciate it. I'm super proud of it.
That's
And the reason why I'm proud of it is I know that every word is an albatross on our businesses. It hangs around their neck, whether it is enforced or not. The fear of that thing just hangs over there. And to reduce the words, like, for example, the podiatrist had 35,687 words in their rules. We knocked it down to 11,000 words. Do you think those doctors are practicing a little bit easier today? Yeah. They're not worried about government looking over their shoulders. Now, I shared with my friend James over here, who I just met today. I hope he calls me a friend too. I shared with my friend James today that here's the secret to this process. By eliminating all those rules, it makes government more efficient. Because now we're not the government of Oprah. You get a car, you get a car, you have a rule, you have a rule. You narrow down the focus of your agency, and you only deal with those things that deal with consumer harm and provide public safety. That's our charge. That's the responsibility that we have. So every time we do away with the rule, we do away with inefficiency on our side. We don't have to have 59 people trying to police 3,000 things. It's only the things that deal with sanitation, only things that deal with public health and safety. We've been using the strategic planning process aggressively as an agency. We go out across the state, we meet with our licensees and our populations and say, what are we doing well? What can we do better? If you were king or queen for a day, what's one rule or law you would change and how we do business? And we've had great information come out of that. In the last 3 strategic planning cycles, we had over 103 statutory recommendations to remove stuff like, if you are the CEO of a hearing instrument fitter company, you had to have the individual hearing instrument fitter license. Well, that just narrowed the world. So Walmart couldn't have a hearing instrument fitter business unless we go get the president of Walmart to get the Texas hearing instrument fitter license. That doesn't make any sense. We worked on removing provisions that say that if you want to be in the driver education business, instead of opening up a brick and mortar school, but you only want to do it online, we took that provision away, and working with some champions like Senator Hancock and Representative Goldman and 1,000 others in the House that believe in what we're doing, it made sense. In that, those 13 programs from the Department of State Health Services, We took them over on October 3rd, 2016. Not like the date stuck in my head, but it is. We took it over on October 3rd, 2016. And since they've been with us, those licensees have experienced a cost savings of $2 million. And what I mean by that is that was $2 million that they had been paying to the state and would still be paying to us. We reduced their fees. We didn't have those rules we had to worry about anymore. We reduced their cost because we were able to streamline and uniform their business practices with our other programs. You bring in 13, why are you going to have these 13 programs look different than the other 36 that you're regulating? You create standardization and uniformity. It's any business practice. You create standardization, uniformity, and repeatability in your business practices, and it makes it easier on those that you are governing. I'm proud of the work that we've done. I'm excited when Governor Abbott sent out a letter on October 8th to all state agency heads saying, I need you to make reducing licensing rules a priority. We were proud to answer back and saying, we're already with you. We're doing it. When he ran for office and he issued the blueprint for Texas, he hasn't changed his position. He's been very clear and provided his great vision on this is what government should look like. Less. It should be smart. It should be dynamic and react. But it should not be in the way. It shouldn't be in the forefront every time someone does a business. Now, when I was this little snot-nosed analyst for the securities board, I was tough as nails because I thought it was my job to find everything that these companies were doing wrong. I thought that's what I was getting paid for. Well, I learned after my mother and father opened up a floral business that every time government jumps in like that, they are pressing down on that small business person in a way they can't even imagine. They're sitting over their kitchen table struggling with, how am I going to comply with this provision? Oh my gosh, I didn't know that rule attached to me. It changed my whole perspective on it. And fortunately, I have an agency and our culture embraces that we're not fearful of having reductions. In the last few strategic plan sessions, we have recommended that 26 license types be deregulated, and they were. 9 programs, complete programs, be deregulated, and they were, because they didn't need to be regulated at the statewide level. We should only focus on those things that the legislature and the governor tells us to do, and we shouldn't run our own private agendas. I love the things that we've done with the agency. I appreciate the opportunity to joust. In this last session, you're not going to believe this, and I don't want anyone to panic, but we worked side by side with TPPF on reforms for criminal justice to help those inmates who are getting out find a quicker path to employment. That unemployment rate that you talked about, Rod, because it's so narrow and so low, the only way people can find those workers, they're going to be the folks coming from out of state. They're going to be the qualified individuals that want to have a second chance coming out of our prisons. They're going to be the kids coming out of foster care. That's the population that's going to fill that void. And so we worked side by side with Derek and his team to come up with some provisions in House Bill 1342 that have changed the whole landscape for how we interact. And we've always looked at those things on a case-by-case basis, but now we have even more tools and better tools to bring about a difference. So I believe in smaller government, but I don't just believe in it, we do it. And if we're screwing up, we own up to it and we fix it. We are going to go back to our strategic planning process in March and April, and we're going to go out there and lay ourselves bare again. What are we doing well? What we can do better? And if you're a king or a queen for a day, what's one change you would make in the way that we do our business and how we have a rule and a statutory provision? And that simple question, James, with the will on the other side to make the changes is all the difference. The last thing I'll add in this process with the health programs, the key to the success, I think, one of the keys, we repealed their existing rules. We didn't try to navigate and meander in their rules. We repealed their rules in totality and built their rule packages coming up. There's a big difference. When you start trying to amend the existing rules, you end up having more rules. But when you repeal everything over here and say, we're only going to start with the things that we need. It sounds like zero-based budgeting. I know Idaho refers to it as zero-based regulation. You can call it what you want. I call it common sense. You start with a clean slate and you put in the things you need and the best things that you've learned. Don't put all the mistakes you had in the other rules. Put in the things that are working and that work well for Texans as well as the agency.
So Brian, let me get you to expand on a couple of things.
Sure.
You mentioned two important focuses y'all have. When you're looking at regulations, people always just think about the impact that that's having, the adverse impact or the constraining impact that that's having on the businesses that are being regulated. But beyond that, the very important point that you mentioned was the barriers to entry from somebody that's not yet regulated and they want to do that business. I mean, we believe in the free market here in the foundation, and we believe that people should have the right to work in the industry and field of their choice. There are obviously some burdens that sometimes that you have to, in certain industries that are regulated, you have to either obtain a license or you have to go through certain hoops and hurdles to make sure that you get there. Oftentimes, and it seems to me in my experience, the public is always of the opinion that the regulated industry does not like the regulations, and it's always the public that wants the regulations. But sometimes the regulated industry, and I think you were touching on this, is reluctant to change their rules and regulations because they don't want new entries into the marketplace, and they don't want those burdens to be reduced. So when you're when you're undertaking some of the efforts that you're talking about and trying to reduce some of those regulations, how do you balance that? Obviously, you've got some folks in-house. Many of these industries have advisory committees within your agency. They're going to tell you, they're going to push back in some cases and say, no, you don't want to reduce too many of those regulations. You'll have just anybody coming in. But then, of course, there is the safety and well-being of the public that you've got to be mindful of. So how do you balance that when you're going through that?
Rod, that's a great question. So James and I were talking about that earlier. There is this moment in time when state agencies put you in the regulatory headlock, and when you've got all these rules around your neck, you actually modify your business practices to adjust to it. You absorb the pain and you live with the pain and frustration of what we've put on you. And so when we go and say, hey, what rules would you like to change? They're like, I've already adjusted to it. Let my new competitor have to struggle and build up their infrastructure to meet your crazy. Well, that's where we have an opportunity. And James, I think I freaked him out earlier. I was like fanboying on him. I was like, I read your article from February 12, 2018. And his article simply said that sometimes the regulators are in the best position to do the cleaning up of regulations because sometimes the industry has said, I've already absorbed that cost. But we know when we have 13 different programs that come in and they look completely different and burdensome than the 36 we already have, we know we have opportunities to clean those programs up. We discovered in some of the health programs that we inherited that if you took an examination and you failed it 3 times, you had to wait a whole year. If you came from out of state, you had to take a written examination, but the in-state person, who was the daughter or the son, didn't have to take any examination to get in the business. They could take an apprenticeship path. And so these artificial barriers that protected that industry, protected that particular business practice, they get lost. We don't. We shine the light of those in the conversations, and I smile and I say, wow, this is a great rule. If you want to keep people out of your business that don't have competition, and there's actually some of them that say, well, we don't want competition. Well, you know, Governor Abbott, who's my boss's boss, has set the vision for us. And the vision is to remove those burdens. It's to get people in business as quickly as possible that are qualified and get out of the way. The process is transparent. We have the dialogue. We do all the filing of the rules and the notice and the public comment period. At our agency, we have so many bites in the public comment period, and I appreciate it. We do a bite at the first advisory board meeting. We get their input and their evaluation. We do the public comment period with the Secretary of State. We come back to the advisory board meeting with all the comments received. We factor those in, and then we go to our commission. Those are all different bites of the apple. But we are allowing the experts to provide their information where they are expert. Meaning, if you are an expert in doing podiatry, I am not going to tell you what to do with the foot, but I'm not going to let you tell me how to do a license, how to move it through the agency, how to conduct a complaint resolution process, that it should be 90 days for the notice. That's one of my heroes right there. The 90 days for the notice versus 60 days, creating consistency in how those programs operate at TDLR lowers the cost. For all of our programs since 2010, we have lowered the cost and kept money in the pockets, as I like to say, kept money in the pockets of our licensees of $20 million cumulative. That's real. That's how it's supposed to work, and we're still doing the job they've asked us to do: investigate, inspect, issue licenses, renew, answer the phone calls, smile on stage at TPPF, wear goofy socks with Kyler Murray's face on it. All those things are required in my job description, and I was able to nail them all in one meeting.
Let me get you to expand real quick before we jump over to James. The audience might be a little cynical. I from time to time have a little cynicism in my heart, and many of them are aware that your agency is undergoing sunset review right
Yes,
now.
sir.
And for those that y'all don't know, it's a tool. It's a very effective tool, or can be effective here in the state of Texas, many states, that every state agency and all their programs and rules and regulations and expenditures have to go through a thorough review by the Sunset Commission here in the state of Texas to determine whether or not that agency and all their regulations should continue to exist or be modified in some form or another. And if the determination is that, no, we don't need it anymore, that agency is sunset and does not exist again. So this agency, the Department of Licensing and Regulation, is undergoing that sunset review right now. And as you mentioned, shout out to Governor Abbott. I'm glad you did that. Governor Abbott did issue that directive to all state agency heads to specifically look at all their underlying regulations and see if there can be efforts made to reduce some of those. So there are a number of tools and initiatives going on in the state of Texas right now that directly impact y'all, that you're having to respond to, in addition to just your general task of regulating the marketplace that they've told you to regulate. So what could you share with us, and if you can't, then tell us, but what can you share with us about how y'all are responding to those challenges?
So the first thing I'll say about the sunset process is I welcome it. And my agency has heard me say that over and over. We're going to be a better agency after the process. And they're going to find out that we're doing some things that we could do better, and we're going to make those changes. The sunset staff are some of the most intelligent folks, private and public sector, I've ever dealt with. They're thorough. And when I say thorough, since October of last year, we've had about 50 plus meetings with the Sunset staff, and they're trying to understand what we do, how we do our business, what the impact is to consumers. They've opened up the floodgates to get comments from our licensees.
And by the way, let me cut you off real quick. And thanks to legislation passed this last session that TPPF was pushing, Representative Schaefer, if you were in the budget hearing that Talmadge Heflin, his session a couple of days ago, Representative Schaefer and Chairman Nelson on the Senate side passed legislation that added to the tools that Sunset is reviewing to include the budgetary process so not just the agency and how effective their programs are, but the amount of money that's being spent on those as well.
Yeah, they added a component called the Strategic Fiscal Review, which is a deeper dive than the normal legislative budget review of your agency. Here's the beauty of our agency in this moment. Last session for our budget, we went through the Strategic Fiscal Review. So now we're going through Sunset, and we're going to do an addendum to that Strategic Fiscal Review. When we complete Sunset this cycle, our agency will go through Sunset again. We're going to do the first 24 programs, which we call our existing programs or legacy programs. And then those new programs that have been recently transferred to us since 2016, they will go through the second Sunset Review. So TDLR is going to, we're going to have, we're under the microscope. But again, philosophically in our agency, we welcome the opportunity. It's going to make us smarter. And if you didn't know this, my mother and father live in Giddings. And my mother and father are impacted by elevators that I regulate, air conditioning contractors, electricians, water well drillers, pump installers, dietitians. I don't actually use one, I should. Dyslexia therapists, the groups go on. We're not just regulators, we're Texans. And our families are impacted by what we do or what we fail to do. And that's something that we talk about at the agency. I think if you make it personal in a positive way, it allows you to be more effective in being true to what the goal is.
But are you going to have recommendations for either Sunset or the governor for additional regulatory restrictions?
We are, and
Not restrictions, but reductions?
Removing those burdens. When we go out in March and April, we're going to be informed, and we're going to gather that information from our staff as well as all of our licensees. When I say all of our licensees, we have a listserv that sends out an email. It goes out to maybe 1.3 million folks on the listserv, and it asks those 4 questions. We survey them. We are not dodging the data. We want to get that data, and from there, we're going to share with Sunset. We're going to do our same process to where, this last session, House Bill 2847, one of the most significant deregulation bills, but if you put it against Senate Bill 2065 from last session, that was the largest occupational deregulation bill that Texas has passed probably in the last 30 years. Every deregulation in that bill came from our recommendations of what we can do and what we don't need to do. And we're going to do the same thing.
Great, thank you. All right, James, take us home. You've done extensive research and analysis of regulations, frankly, all across the country. So tell us a little bit about what you have found, what your research shows, and I guess how Texas fares. We're all going to hold our breath here, and maybe give us some ideas of what we should be looking at.
Sure. So I've spent the last several years involved in a project to try to measure regulation across the 50 states. We really historically have not had very good measures of regulation, so we haven't been able to compare. How does Texas compare to California? How does Mississippi compare to Alabama?
Because there are thousands and thousands of those regulations
There's too much.
Scattered all over the country.
But now modern technology really is what is allowing us to, for the first time, start to cast a light on the regulatory state across the country. And so I've been involved in a project at Mercatus that we call Reg Data, and it's an effort to use text analysis to analyze bodies of law, like regulatory codes, and convert it into data. And we're finding that this data is used both by academic researchers. Our data is being published in academic journals, top economists around the country are using the data, but it's also being used by policymakers to track the progress of their regulatory reduction efforts, such as 1 and 2 out policies. So at the simplest level, we just scan through a state's administrative code and count up the number of words in it. Sounds very simple. The Texas Administrative Code has about 15 million words in it. And it would take you about 21 weeks to read all of those regulations if you just read regulations as a full-time job for 40 hours a week. We also look at the number of restrictive terms like shall, must, may not, prohibited, and required. Those are the 5 key terms we look for. And this is a proxy for the number of regulatory requirements or mandates in the code. The Texas Administrative Code has about 227,000 of those restrictive terms. So to put that in context, by this measure, you are the 5th most regulated state in the country. The top states are California, New York, Illinois, Ohio, and then Texas. California has about 400,000 regulatory restrictions in its title. The least regulated state, by our measure, is, according to our most recent data, it's South Dakota with about 44,000 restrictions. Idaho actually claims to have surpassed South Dakota just in the last couple of months, and we're rerunning the numbers now to confirm that. So Idaho may have as low as like 40,000 restrictions. So there's big variation across the country. California has about 10 times as much regulation as South Dakota or Illinois. There are more than 1 million regulatory restrictions in the Code of Federal Regulations and more than 100 million words. So the Code of Federal Regulations is 10 times the size of some states' codes. And it would take about 3 years to read the federal code. And keep in mind, this is just the regulatory codes I'm talking about. So there's statutory codes where when legislatures pass laws, it gets turned into a statute. Then there's administrative law, which is the regulatory code. This is the body of law that the various executive agencies write. And then there's all these policy documents and guidance documents, which Jeff mentioned earlier. That's another layer of law. So our reg data project for now is just looking at administrative law, but the technology can be expanded to other bodies of law. And we plan on doing that eventually too. Most of the regulation in Texas tends to be targeting manufacturing, food production, healthcare, utilities. These are among the most regulated industries. The biggest titles in the regulatory code were the the economic regulation title, which is like utilities, gaming, liquor regulation. There are about 33,000 restrictions in that title alone. Environmental quality had about the same number of restrictions, a little over 30,000. Social assistance, health and services, they had about 20,000 restrictions in their titles. So you can break down our metrics by agency. We use machine learning technology to identify which industries are the most regulated. And so it's pretty actually sophisticated data that we're producing, and that's why a lot of economists are loving it and picking up on it.
So tell us a little bit about one in and two out. You're familiar with that term. I saw it in a piece that I read where you were citing some of that. And I think specifically the state of Ohio, and I know some other states were looking at that. So what is it? How does it work? And is that something that you would recommend for other states such as Texas?
So one in, two out in some ways is a symbol that represents a broader package of regulatory reforms. It tends to get the most attention, and it's a very good device for communicating to the public. If you're a president or a governor, I'm targeting regulatory burdens. But it's not necessarily the key to a successful regulatory reduction effort. Now, a number of states now have experimented with some kind of one in, two out policy. So for every new regulation, they're going to eliminate two. The Trump administration has also issued an executive order along these lines. But the devil really is always in the details. And one of the most critical aspects of any reform like this, and these are broadly red tape reduction reforms. They're designed to streamline the regulatory code, make it simpler, reduce regulatory burdens. But one of the most critical elements is having a measure of regulation, okay? A simple measure of regulation that you can use to track your progress. So Brian mentioned that you cut 47%, I think, of the words in one of your titles. I bet you wouldn't have been able to do that if you hadn't been tracking how many words are in the title. And the history of regulatory review and reform over the last few decades is that it's very common for a governor or a president to come into office and say, I'm going to have a review of our regulations, and not much is accomplished because they don't really know where they started from, they're not really sure where they end up, and there's not a goal in mind that they're working towards. And so several states have been experimenting with one in, two out, but the details are important. So I'll just go over a few examples. So one is Idaho. Idaho got a new governor about a year ago. His name's Brad Little, and he issued an executive order, and it said, among other things, for every new regulation we add, we're going to remove two. But in practice, what they've been doing is tracking the number of words that they're adding and taking away from the code, and tracking the number of regulatory restrictions, the Mercatus metric. They've also been counting pages and chapters, and they actually have kind of a host of metrics that they're following. Now, Idaho got kind of a unique opportunity last summer. They are a state that has a sunset process for actually their entire regulatory code. Every year, their entire regulatory code will expire on July 1st unless the legislature passes a bill to reauthorize it. This was basically set up to just give the legislature more say in the regulatory process so they could approve or strike down regulations. Well, for the first time last spring, the legislature, due to some infighting between the different chambers, left town without reauthorizing the code. This has never happened before.
The entire code.
The entire code. So July 1st, this actually happened, the entire regulatory code in Idaho expired. Now, does this mean that there were no regulations in the books? No. What it did was it created an unprecedented opportunity for the governor to essentially pick and choose which regulations to keep. So the burden of proof switched. Whereas before, this opportunity. He would have had to issue a regulation to remove a regulation. Now he had to issue a regulation to save a regulation, and the default was that it expired. And this really emphasizes this idea of zero-based regulation. Let's start from scratch. They essentially just rewrote the code and replaced the old version. And so they stayed in compliance with the relevant statutes that they needed to comply with, but they eliminated about 20% of chapters, 10% of pages, something like 30,000 regulatory restrictions in a very short period of time. And their reforms are ongoing. They're still continuing to cut. The governor of Idaho just issued in the last couple of weeks another executive order that has put a cap on the amount of regulation so that they're at their new lower level, so essentially they can't return back to the level where they were at before. And it directs agencies to repeal their regulatory chapters every 5 years. So every 5 years, they have to issue a regulation repealing everything that they have, and then whatever they want to keep, they have to promulgate again. And it'll have to go through some requirements like cost-benefit analysis. So 1 and 2 out has been a good symbol to communicate to the public, hey, red tape reduction is a priority. It also sends a message to regulatory agencies. Look, we're going to focus more on removing regulations right now than we are in adding them. But it doesn't really, in practice, it doesn't mean that every time an agency writes a regulation, they say, here's 2 I'm going to remove. That's
Well, and there would be restrictions on that, obviously. I can imagine a state agency would say, well, I'd be fine with removing 2 regulations, but every single one of my regulations, or most of these that I'm going through, are statutorily directed. And so, many times, and I think Jeff was mentioning this earlier, you look at the statute, but if you look at sometimes the statute is very specific, as you said, that it'll direct a state agency to adopt rules to do such and such, and it's very, very specific about what they want the agency to do. So they don't have much discretion there. They have to adopt those rules. Other times, it's simply saying we give general rulemaking authority to that agency to adopt rules and regulations in order to further the administrative efforts of the agency in adopting all those other specific rules. So tell us a little bit about the pushback that I guess some of these states would have when they're undergoing the 1 and 2 out. I mean, that seems like a hurdle.
Well, so a best practice when you're starting a reform like this is to have an initial review of all the regulations on the books. Direct every agency to review their rules and count up either how many words they have, how many requirements they have, how many regulatory restrictions, whatever your measure might be. And as part of that effort, they should also identify whether regulations are discretionary or whether they're mandated by some state or federal law, and if so, which law. And some states are actually doing this. So for example, in Virginia in 2018, they passed something called the Regulatory Reduction Pilot Program. And it's starting at 2 agencies, primarily engaged in occupational licensing, actually. They had to produce a count of all their regulatory requirements. They had about 6,000, I think, between them. And they were directed by law to cut by 25%. And they opted to just make that 25% relative to just out of the discretionary requirements, as opposed to the overall amount, because that would have required legal changes. But nonetheless, they found 80% of their requirements were discretionary. And that review is being extended to the other regulatory departments in the state. They're producing their counts this year, and from what I've heard, they're also going to have to start cutting. Arizona is another state that had a review of their regulations a couple of years ago, and they identified where the original authority came from for every regulation. They found that about 57% of their regulations were discretionary. And I think only about 10% were mandated by federal law and maybe 30% by state law. So governors have a lot of authority to update the regulatory code, remove regulations, without any statutory changes. The anecdotal evidence we have is that most regulation is probably discretionary. But obviously, statutes are going to have to be changed to really make substantive changes to the regulatory burden. So, as Brian mentioned, it's important when you're reviewing your regulations to identify which regulations would require statutory changes, and then those recommendations can be made to the legislature.
We're running out of time. Let me just end this, and then we're going to shift over to some Q&A. But let me impress upon y'all one thing. A lot of people forget that you have an opportunity, the public has an opportunity, not just the regulated entities, but the public in general has an opportunity to be heard before state agencies. Everybody knows about going to the legislature or calling the governor's office, but every time one of these rules is adopted by law in the government code and the Open Meetings and Open Records Act, they have to provide notice of these rules and regulations. They have to have input. Brian mentioned most agencies go through a series of opportunities for public to provide input, informally, formally. Avail yourself of that if you have the time and the effort. If it's an issue that you're concerned about, if it was an issue that you were concerned about, either favorable or unfavorable at the legislature when a statute is being adopted, make sure you follow through when it gets to the state agency, because that's where, again, where we say the details come out. And if you're not there, the devil will rule. So I do encourage everybody to stay impacted. The good news, as I think we all heard here, is there are a lot of tools in Texas and in many other states, and certainly at the federal level. It all comes from leadership. We've got good leadership with Governor Abbott right now, directing the agencies to take a hard look at these. I think he's going to continue to press on that. That will entail leadership at the top of these agencies to follow through, and then ultimately at the Attorney General's office, General Paxton and Jeff are going to be keeping an eye on some of those too. So I think there's a lot of folks outside of what you see on a daily basis that actually try to constrain some of this regulatory overreach, but it does take your input, so avail yourself of that. So with that, I think we're out of time with these. Before we go to Q&A, join me in another round of applause. Thank our panel here. All right. Do we have a microphone? Looks like we've got some hands right here on the end, on the aisle there.
Thanks. Thank you very much. Brian, you mentioned the 280-something thousand words of rules. Where do these rules come from, and who is writing those 281,000 words?
It's a great question. So the programs were inherited from the Department of State Health Services, and the 13 programs that were transferred to us, they were independent boards. And so each board was saying, here's what we need. And then the other board would say, here's what we need. And so they were being drafted by the staffs that supported them. But you saw this last session with Senate Bill 1995 with the creation of the Regulatory Compliance Division at the governor's office. It's focusing on those boards that are dominated by market participants, saying, hey, you can't just run amok. That's what we inherited. We inherited 13 independent boards, independently developing rules that ran above what they should have.
But to follow up on that, Brian, I'm assuming, and I think in your agency, y'all draft the rules and ultimately adopt them, but you've got, I mentioned earlier, you've got advisory.
We have advisory boards, so they're not policy making,
Right.
They're not decision
So
makers
in the
now.
past,
My commission.
in the past, when that was a standalone licensing agency, that board
made the
would have
call.
been making the call. Now they simply advise you or advise the agency, and then y'all make the call.
And it goes up to my 7 commissioners. You know, everyone in the room has 7 bosses. I have 7 bosses that are appointed by the governor, and so we're getting that push and that vision of being streamlined and being focused. So they came from each board calling its own shot, and I think the transfer has revealed that there's been some value.
And that structure is obviously up to the legislative body as to, how many agencies, standalone agencies they want to have. The trend over the last several years has been to eliminate some of those standalone smaller agencies, merge them into the Department of Licensing Regulation, or merge them together in other agencies. I was a product of that at one sunset review. So, and a lot of that is in the eye of having more administrative efficiencies, and I think it does work pretty well for that. But good question. Over here, right here. I'm going to get all the way.
Hello. As a small business owner, formerly in California, now in Texas, I can tell you that most of us just assume we're out of compliance with something. We try to be honorable. We try to run our businesses with integrity and do right by our customers. But when I talk to other business owners, we all are all over the map on different things and interpretations. So I'm wondering about enforcement. And I appreciate, Brian, you said that you had shifted your view in a former position, understanding that it wasn't your job to find every possible violation. So where are you at now with enforcement, and when you find a violation, how much are you looking at the intent? In other words, did this business owner intend to harm anyone, with his violation, and what can you do to minimize the penalties there?
That's a great
Great question, yeah, before you answer that, because we didn't really touch on the enforcement, but that's what I hinted at earlier. These aren't just regulations as like guidance. They have, remember, again, they have the force of law. You violate them at your own peril. There are administrative penalties, or sometimes you could lose a license and you're no longer able to practice in that field. So it's very, very important, the efforts of oversight, yeah.
That's a great question. So probably about 5 years ago, we added a strategic goal to our agency, so it permeates our enforcement efforts. And it simply says that we are going to focus our limited enforcement resources on those complaints that cause consumer harm or violate public safety. That changed our whole world. Before, we would go in and do a cosmetology inspection of the salon, and we'd find all these violations. Well, the majority of them could be fixed in that moment. Oh, I didn't know I needed to have that. Well, at the time, probably about 5.5 years ago, those are direct to enforcement. And now they had to deal with our attorneys. When we put in place this goal, it narrowed that list. And so that direct to enforcement list went from 35 items down to 9 to 12. And so we've narrowed it, saying, does this truly have consumer harm? When we reach out to that business owner, we say, here's what we think we found, and here's the penalty, based on a penalty matrix that's public, so everyone knows. They can look at our webpage and see that if I have a violation of this, here's the maximum penalty that I could receive. But we tell them, here's what we think we're going to assess you, and then we engage in that conversation, and we do discover that business owner has made a mistake. They weren't intentional. There's no pattern of violation against consumers. We've added some provisions. Instead of them giving all the penalty money to the state that goes over into the general revenue fund, we now say, hey, why don't you work with the vehicle that you towed inappropriately and pay them back the money for the tow? And that restitution now goes to the consumer, doesn't go to the state. And so we've made some really good changes over the years. I would dare say that we are learning our way in the massage program. Probably 7 years ago, our penalties on the towing industry they were entirely too high. But we didn't know the program. And as we start learning those programs, we're recognizing how the business practices work and what's a good business practice versus a bad one. And the advisory boards are key in that education for us.
It's a great question, and let me add to that. Again, leadership from the top from the governor's office and the legislature over the last several years, I think, has really translated down to the agencies that we really want compliance more than penalties. Now, sometimes penalties are going to be warranted, but Brian's exactly right. If you get an inquiry or a complaint letter or something that deserves your response, or they want your response, the quicker you get it to the agency, I think you're more likely to be able to resolve it informally. Because he's right. Once it gets to enforcement, it's not that you can't stop that. It's just the lawyers are already drafting paperwork and whatnot, and that's what I do too. But Jeff will be on this. But it's the agencies are also required under budgetary guidance and performance measures to enforce certain violations. And so the quicker you can get that to an informal process, the better off you'll be. Yeah, back over here on the closest, and then we'll come back to you.
This is for Mr. Mateer. You mentioned earlier that you don't believe the Texas Supreme Court has a Chevron problem, and I'm inclined to agree. It seems like their standard is more of a Skidmore standard, which the court defers when the agency offers persuasive reasoning. So 2 questions on that. Do you think that is true of the lower courts of appeals, say the Third Court, or is there a danger with the shifting political composition of the other courts of appeals that they're not following the Supreme Court's guidance? And then secondly, do you think there would be any benefit to modifying like the code of judicial construction to just clarify that one shouldn't give blanket Chevron-type deference? For example, Arizona passed a law that did that, I believe, in 2018.
Yeah, no. The first question's hard because obviously we elect our judges, so you've got a completely different. I mean, the easy is to make sure that we put people into judgeships who actually follow the law. And so what the question? I'm sorry. Sorry about that. Yeah. So because we elect our judges, you can have people elected, and one might submit this last round of elections where some very good judges were voted out by the people. Use the third court, for example, which is, for those who don't know, that's the court here in Austin and the surrounding counties, flipped from a Republican majority to a Democrat majority. We don't know a lot about some of those judges. I will tell you from the state's perspective, obviously because that's the court we end up in the most on the appellate level on the way to sometimes to the Supreme Court. We have a lot of concerns about that. I don't know if there was a panel at this policy conference about the election versus appointment of judges. That's obviously something that the governor has talked about, something the attorney general has talked about as well, and the lieutenant governor. And I think it's going to be something that there were a couple different bills in the legislature this last time about that. I think it's going to be an ongoing. But I think part of that is they need to follow the law, and I think I agree with you. I think the assessment that the Texas Supreme Court, I would call it limited deference. And actually, I think it's just following the law because, quite frankly, the test in Texas and the federal tests are sort of the same, except the Texas judges at the Supreme Court level actually follow the law. And so I think that's, it's hard to tell. I mean, I think the verdict, what's going to happen in the Houston Court of Appeals with the flip and the Dallas Court of Appeal because of the flip. But yes, we have concerns about that. I think I am familiar with the Arizona. I think that could be a solution. But if you'll ignore precedent at the Texas Supreme Court, what I've learned is judges will ignore even statutes. It's more important that we're actually making sure the people, the men and women who are serving as judges, actually adhere to the rule of law, actually adhere to precedent. I think that's the bigger ask. And if perhaps we'll be at a point where the way we've elected judges in the past is something we have to reconsider, and I think our state is trying to reconsider that.
Yeah, just real quickly, Chevron and all these judicial standards basically exist because of an underlying problem, which is that legislatures write vague laws. And somebody is going to have to determine what vague laws mean. And there are pros and cons to letting judges do it, and there are pros and cons to letting regulatory agencies do it. But ultimately, the solution is going to have to be that legislators are more clear about what the law means, and they don't try to evade answering the tough questions or kick the can over to the regulatory agencies. And that's ultimately where this problem is coming from. I would just suggest one possible solution, which is the system that West Virginia has, where every regulation that they finalize has to get unique approval from the legislature. So essentially, there is no discretion. I mean, regulatory agencies do write some regulations, but really they have to go, it's an approval process. They bring the regulation to the legislature, and the legislature passes a law to finalize it. So that's another potential option.
Well, and to expand on what you said earlier, I wanted to mention that earlier when we were talking about these efforts to reduce the numbers of regulations, or as you put it, because I don't know what the definition of a regulation is. You have chapters, sections, lines. So yeah, define that first, words, restrictive words, whatnot. But when you get into that, we were talking earlier about very specific direction from the legislature to adopt versus general rulemaking authority. I don't want anybody to think that every rule that's adopted under general rulemaking authority has no purpose, because what James just brought up was a very clear purpose for an agency that most parties would agree with, which is that either Jeff has had to take a rule to court or defend a rule in court because there was some vagueness to the statutory direction and or a definition. And so the rule oftentimes is there to add some context or some definition. Now, obviously, again, these are the details, so the regulation is certainly worthy of taking a close scrutiny, but there is a purpose to trying to add some definition to that so that you don't end up with just countless cases in court challenging every effort to enforce a vague statute or rule otherwise. So it's not that you're going to be able to eliminate every one of those rules, but it certainly bears some attention. Back over here first, I think.
I'm from Houston, and the citizens of Houston are looking for relief in one area, and there may be a confusion between municipal regulations and state regulations, but as you know, Houston is the sex trafficking capital of the country. This is a huge scandal. The mayor, who was recently reelected, which was really unfortunate, was brought a list of well over 100 unlicensed massage parlors by Jeremiah Rising, a group that works with women being trafficked. And he said he didn't have the funds to engage in seeking them just to get regulation, which is a tiny little improvement. So they went to the major law firms who said, we will do all file all the papers pro bono. They went back to him. He said, what do you not understand about? I'm not interested. Are the rules governing massage parlors municipal rules that he has control over, or do they not fall under your state regulatory agency?
That's a great question. They're both. And one of the things that we've just put in place, the legislature invested nearly $90 million this last session to combat human trafficking. They gave us funds for an anti-trafficking unit that we have populated. The team is actually going through training right now. And their focus, their sole focus day to day is going to be going into the illicit massage businesses. Houston obviously, unfortunately, leads the nation in that area. The statistic that there are more, massage parlors and brothels than there are Starbucks, that's horrible.
They're on every corner
They're
in
on
the
every
last
corner.
5 years.
And our agency, in working with the other partners, local law enforcement, in fact, we're going to be in Houston next week for training, meeting with the mayor's office, meeting with Senator Huffman's office, Representative Thompson's office, the Houston Police Department's human trafficking unit. We're going to tour and see where some of these locations, but our staff will be going into every last one of those over the next 12 months. Good. And they're going to pop up in someone else's neighborhood, and we're going to go into them when they go over there, and they're going to pop up in someone else's neighborhood, but they're now going to recognize that we are following them. We are following them, and we're doing what we can to bring the negative attention to it. And I've got a staffer back there that I'm going to have her get with you, because if there's something we can do with those lawyers that are putting some money up, hey, we don't mind throwing that away either.
And I would just add, and I know we're out of time, I just add that stay tuned, because there's some things that we can't, and I'm looking back at one of mine, I don't think there's something we can announce right now, but stay tuned. Okay. We know about the problem you're having in Houston.
Well, and it's not going to be solved from the mayor's office.
So, folks, on that note, I like the last phrase there, stay tuned. There's a lot going on in Texas and elsewhere. I appreciate your time. One last round of applause. Thank you very much.